Hello learners and welcome back to this video on removal of directors and key managerial personnel. I will start this topic with an important section. Under section 169 of the Companies Act, a company can remove a director before the end of their term by passing an ordinary resolution. The provisions of section 169 can apply regardless of any method which was used for the appointment of the director. The provisions of section 169 take precedence over any conflicting rules in the company's articles of association or any agreement made with the director. In other words, even if the company's articles of association or an agreement with the director states otherwise, the company can still remove the director under section 169. Directors of a company can be removed through two ways, namely removal of director by shareholders and removal of director by the National Company Law Tribunal. Let's first see the removal of directors by the shareholders. Under section 169, a company may remove a director before the end of their term by passing an ordinary resolution provided that the director is given a reasonable opportunity to be heard. Opportunity to be heard means that the director is given time and space to prove himself not guilty. This type of removal is not applicable to the directors who are appointed by the tribunal. For an independent director who was reappointed for a second term, removal can only happen through a special resolution after offering the director a reasonable opportunity to be heard. The provision related to the removal shall not apply where the company has availed itself of the option to appoint not less than 2/3 of the total number of the directors according to the principle of proportional representation. The following procedure is required to be adopted for removal of a director. First, special notice from the members of the company is passed in an ordinary resolution proposing that they want to remove a particular director due to some necessary situations. Then the copy of this special notice is sent to the proposed director who is to be removed. A general meeting is then called. A notice of this meeting is sent to all the members, and along with this notice, the representations which are made by the accused directors are also attached. However, the National Company Law Tribunal, on an application of the company or any other person who claims to be aggrieved, on having satisfied, may dispense with the procedure of sending a copy of representation. In the next phase, the company will hold the general meeting and pass the proposed resolution by an ordinary resolution. In the case of a listed company, it is required to forward a copy of the proceedings of the meetings within 24 hours of the occurrence of the event to the stock exchanges where the company is listed. Next, the company has to file particular of director in form DIR 12 with the registrar of companies within 30 days of the removal after paying the required fees electronically. For the purpose of filling form DIR 12, the following attachments are required: notice of resignation, evidence of cessation, interest in other entities. The company should ensure that said form is digitally signed by the managing director or manager or secretary of the company and also certified by a company secretary or chartered accountant or cost accountant. Also, the particulars of the director and other aspects of the directors have accordingly to be modified in the registers maintained by the company. Finally, for the protection of the company and benefit of the general public, the company should give a general public notice in the newspaper regarding removal of the director. Next is removal of director by the National Company Law Tribunal. Now, in cases where an application has been made to the National Company Law Tribunal against a director for prevention of oppression or mismanagement, then the tribunal can remove the director in question. Oppression or mismanagement means that a director has not been fair in his dealings. Let's now move to the next topic, which is key managerial personnel. So, who are key managerial personnel or KMP? They are the full-time employees of a company. They hold crucial roles in a company and act as a main link between the company and its stakeholders. KMP are the executive management of a company that is in charge of running the business of a company on a daily basis. The Companies Act 2013 refers to these persons or people as key management personnel. They are the main contact between the company and its stakeholders, while the board of directors oversee the company. It is the key managerial personnel who create and carry out the company's strategies. According to Section 2, subsection 51, key managerial personnel in relation to a company means the chief executive officer or the managing director or the manager, the company secretary, the whole-time director, the chief financial officer, such other officer not more than one level below the directors, such other officers as may be prescribed. Let us see the rules and procedures to appoint key managerial personnel. First, the company should conduct a board meeting and pass a board resolution that outlines the terms and conditions for the appointment of key managerial personnel. Second, the rule here is that a whole-time key managerial personnel can hold office in only one company except for its subsidiary at any given time. A company may appoint or employ a person as its managing director if they are already serving as the managing director or manager of one and of not more than one other company. Such an appointment or employment must be approved by a resolution passed at a board meeting with the consent of all the directors present. Specific notice must be given for the meeting and the resolution to be discussed. If the position of a whole-time key managerial personnel becomes vacant, the board must fill the vacancy at a board meeting within 6 months. The company should file DIR 12, Particulars of Appointment of Directors and Key Managerial and Any Changes form, along with the prescribed fees as per the Companies Act. Lastly, let us look at the duties, powers and responsibility of key managerial personnel. Firstly, KMP should participate in board meetings and contribute towards policy making and goal setting. KMP is responsible for implementing policies set by the board of directors. They are responsible for communicating and interpreting company policies to employees. Their duty is also reviewing and reporting the company's performance, including financial and operational progress. KMP also looks into appointing senior executives and key personnel. KMP also look into designing compensation and employment plans in line with company's policies. Finally, encouraging high employee morale and fostering a sense of belonging within the company is also a responsibility of KMP. So, this was the session on removal of directors and meaning, role and appointment of key managerial personnel. Thank you for tuning in.